With new laws impacting the right to protest in New South Wales, some experts are saying the state now has the most severe anti-protest regime in the country. So what are the anti-protest laws in New South Wales and how have they changed? So there is no express right to protest in New South Wales, but it is covered in common law and by the Australian Constitution, which the High Court has found implies the right to freedom of political communication. Governments can't create laws that significantly impede this right, but there are many anti-protest laws that critics claim have eroded it. And the Human Rights Law Centre has found that New South Wales has introduced more anti-protest laws than any other state or territory. Now, the most high profile of these anti-protest laws were passed in 2022 by the then New South Wales Liberal government with the support of Labor. So after a series of protests by climate group Blockade Australia, the government made it an offence for protesters to obstruct major roads, transport facilities and ports. And the maximum penalty for this is 2 years in prison or a $22,000 fine. Many states and territories have since followed suit and introduced a similar offence. Now, moving to the latest change, in February the government significantly expanded police powers to move protesters along. So until recently, police could only issue a move-on order if protests were obstructing traffic or posing a serious risk to someone's safety. Now, police can issue a move-on order if a protest is taking place near a place of worship. The protest doesn't need to be connected in any way with the place of worship or even be about religion. It could be anything. And there's no definition of what near means, so that's left to police discretion. Sites in Sydney where protests commonly take place, such as Town Hall and Hyde Park, those are close to places of worship. The next thing that's important to know is protests don't require police approval. And while individual protesters can be charged with an offence because of their conduct during a protest, experts say protests in and of themselves are not unlawful. So it can be confusing when authorities say a protest is unauthorised or unlawful, as the New South Wales Police Minister Yasmin Catley did about pro-Palestine protests outside the Sydney Opera House. An application known as a Form 1 is a permit-like system that protest organisers can send to the police ahead of time. And if the police accept it, protesters are provided certain legal protections. It means you won't be at risk of facing a maximum $22,000 fine or 2 years in prison for blocking a major road if a Form 1 has approved you to do so. If police oppose the Form 1, a court has the final say. So this is why we've seen some high-profile protests recently front court, and that includes Rising Tide's blockade of the Newcastle port last year. So after the police knocked back the climate group's Form 1, the court sided with police. But organisers went ahead with the protests regardless, because the court's decision simply meant that protesters were not protected from being charged under those protest laws. Now, while it's not compulsory to submit a Form 1, some legal experts have argued that protest laws are now so harsh that protesters feel like the form is a prerequisite. Some protest laws have been challenged before the courts. So in 2023, the climate group Knitting Nanas had a section of the anti-protest laws overturned after the court found they were constitutionally invalid. There is also a legal challenge by the Sydney-based Palestine Action Group against the laws that restrict the right to protest near places of worship. The Human Rights Law Centre have said that because these laws are so broad and vague, it makes it a challenge for protesters to know whether or not they've broken the law, and police have been given a lot of discretionary power over applying protest laws. And all of that is just what's happening in New South Wales. So the Human Rights Law Centre last year looked at more than 49 laws introduced by federal and state governments over the past 2 decades. They argued that across the country, these laws have eroded the right to protest.